Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today what I'm going to talk about is how to file a motion in limine in a Connecticut family law case. So a motion in limine is basically a motion you're filing with the court asking for the judge to grant your request that certain evidence the other side is trying to present be denied from being introduced into evidence and denied from the judge viewing those documents. So allow me to share my screen and I'll show you the relevant practice book section. So it's practice book section 15-3, which says the judicial authority to whom a case has been assigned for trial may, in its discretion, entertain a motion in limine made by any party regarding the admission or exclusion of anticipated evidence. If a case has not yet been assigned for trial, a judicial authority may, for good cause shown, entertain the motion. Such motion shall be in writing and shall describe the anticipated evidence and the prejudice which may result therefrom. All interested parties shall be afforded an opportunity to be heard regarding the motion and the requested relief. So let me back up to the prejudice, the anticipated evidence and the prejudice. So basically, what that means is more or less if the person against whom the evidence is being presented is prejudice, so kind of treated unfairly. If it's unfair for them in some way for the evidence to be presented, then the court will grant the motion in limine and not allow the evidence in. The judicial authority may grant the relief sought in the motion or such other relief as it may deem appropriate, may deny the motion with or without prejudice to its later renewal, or may reserve decision thereon until a later time in the proceeding. So let me show you a sample motion in limine. Forgive me if you hear a little noise in the background. My dog is digging a hole on a mattress. Or on his mattress. All right, so here is a sample motion. So this is a scenario where a trial is coming up, and what often happens is there are what are called standing orders that says that, both sides have to exchange their proposed witnesses that they're planning to have testify, their proposed exhibits that they're presenting. They have to exchange those documents within a certain period of time. Usually it's 5 days or 10 days, depending on the situation. So if the other side has failed to disclose the documents that they're planning to present, that's not really fair to you because you don't have an opportunity to prepare if you don't know what their evidence is going to be. So you might want to file a motion in limine. If you're an attorney, I generally don't file these without at least giving the other side a heads up of hey, just so you know, I'm going to file this. So get your stuff done. It's kind of a professional courtesy thing where you're not, at least that's how I like to operate, where you're not ambushing them, trying to screw them over with not being able to present any evidence. So here's a sample motion. So it's pursuant to blah, 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 the practice book section. You're submitting this motion as it relates to a trial, which is scheduled on so-and-so a date. And then again, this is the scenario of them not following that standing order. So on so-and-so a date, the court issued a notice regarding the trial date as follows. Trial is scheduled for the above day and time. Counsel and or self-represented party shall comply with the standing orders. Standing orders can be viewed on the judicial website. And as of so-and-so a date, they still haven't turned over any documents. And, we are prejudiced by the plaintiff failing to comply with that standing order. And the order specifically says if a party does not follow this order, the party may have sanctions imposed on them by the court, which may include a monetary sanction, exclusion of evidence, or the entry of a non-suit, default, or dismissal. And it also says that the court may entertain a motion in limine made by a party trying to exclude evidence. And then, put a little bit of a description that despite failing to comply with the standing order, the defendant anticipates that the plaintiff will attempt to offer exhibits and testimony through witnesses as evidence at the time of trial, which have not been produced in compliance with the standing order, And this is kind of talks about why we don't present evidence at the last minute. So presenting plaintiff to offer evidence not previously produced as ordered by the court or as required by the standing order would constitute trial by ambush. And it is well established that ambush is not the way that cases are tried in this state. So again, the courts don't like to encourage surprising the other side with stuff. You're supposed to disclose all of the documents that you're planning to present, at least in a family case or a divorce case. So then you put the relief that you're seeking. So in this situation, you're seeking that they be precluded from introducing evidence or witness testimony because they didn't comply with the standing order. Or you might want to put an alternative request that the court enter monetary sanctions against the defendant for not complying with the court orders. So those are the basics of, that's a certain sample motion in limine. There may be other reasons why you want to file a motion in limine. Maybe the other side's trying to present evidence that, documentation that's privileged, like certain medical records that shouldn't be viewed or are irrelevant. So confident, privileged stuff shouldn't be presented, or maybe, an expert witness who isn't qualified to testify. Maybe they disclosed an expert and they're trying to get that expert to testify, but they're really not a qualified expert. And, you can watch our video on expert witness testimony if you want help with that. So there's kind of an unlimited range of scenarios in which you would want to present a motion in limine. Depends on the situation. You'll obviously have to tailor the language of your motion based on your specific situation. So if you want to get a copy of that sample motion, you can get it on our website. And that's it. If you have any questions, as usual, feel free to call our office and we'd be happy to answer any questions that you have.